Hi, everyone. I'm Rachel Wolfson, the host and founder of Web3 Deep Dive Podcast. Web3 Deep Dive Podcast focuses on real-world Web3 use cases to help you better understand how Web3 is being applied today and how it may be leveraged in the future. If this sounds interesting, I encourage you to subscribe, like, and share the content that you're seeing today to help spread the word about Web3. I'd also like to take the time to thank Web3 Deep Dive sponsors. Animoca Brands is sponsoring today's episode. As a worldwide industry leader in digital entertainment, blockchain, and digital property rights, Animoca Brands plays a key role in the future growth of Web3 and the open metaverse. With a portfolio of over 450 investments in products like the Sandbox, Phantom Galaxies, Life Beyond, and Mochaverse, Animoca Brands will keep building a better and fairer Web3 ecosystem, bringing true digital property rights to all internet users. Hey everyone, welcome back to Web3 Deep Dive. I'm so excited for today's episode. Today I'll be interviewing Margaret Rosenfeld. She's the Chief Legal Officer at Cube Exchange, and Lewis Cohen, who's the co-founder of DLx Law, which is a law firm that specializes in crypto and blockchain technology. So, hey guys, how's it going?
Great.
Great. Thanks so much for having us on here. And you have two of my the biggest securities nerds in the space on with you right now.
Yeah, well, that's the point, because I forgot to mention in the intro, today's episode, we're going to be speaking all about the XRP court ruling, which is just, creating so much buzz in the crypto industry right now and in the Web3 industry. So excited to have you guys here. Before we get started, Lewis, how about we start with you? Can you just tell our listeners a little bit about your background, and then Margaret will go into your background, and then we'll kick off the interview.
Sure, Rachel. Hey, thank you. And again, thanks for having us on your show. Really pleased to be here. My background, I think, has some similarities to that of Margaret. I was a traditional securities lawyer working in traditional finance for many years, working in large law firms. I was a partner in two big international law firms. And I got really interested in blockchain and crypto somewhere along the way. My case was somewhat later than some, earlier than others, around 2015-16. I started the blockchain group at my large law firm, but I realized that large law firms really are struggling to get into the weeds of what's going on. So we started DLx Law a little over 5 years ago. And we just have a good time working with people and some of the brightest, most interesting folks out there in the crypto space right now.
Awesome. Wonderful. Okay, Margaret, a little bit about your background.
Sure. So up until a year ago, I had a very similar background to Lewis. And we've known each other for a while. I have practiced globally with large law firms from 1997, before there was even a Web 1, doing securities law and corporate law, IPOs, and everything that you can imagine. Always focused primarily in the tech area. So got into blockchain technology in around 2012 time period, and that was more with operating companies and how they were using the technology. But then it sped up in 17 to 19 when we just had the first ICO craze, and Lewis and I were sitting there going, the Howey test, how does this work? And so that pulled us, both of us, in further and further into this space. About a year ago, I said, hey, I practiced law 25 years. I want to spend the next 25 years being in-house somewhere and actually being part of building what's going on for Web3. So now I'm the Chief Legal Officer of Cube Exchange, and it's a hybrid DEX and centralized exchange, and we announced that we've chosen Australia as our launch country, and we're launching there.
Awesome, wonderful. And we'll talk a little bit more about why you guys are launching in Australia in a bit. Let's start off by unpacking the XRP court ruling, because there's a lot of positive sentiment in the industry right now saying that, this is a major milestone, major win for the crypto industry with XRP tokens that are sold on digital assets exchange. They are not securities. But there's more to this. So I want you guys to kind of unpack this. Lewis, do you maybe want to start off by telling our listeners what's been going on and what we need to know?
Yeah, sure. I think it's worthwhile, Rachel, just kind of going back a couple of steps. As Margaret indicated, the light bulb went off, particularly once Ethereum was up and running, that it would be pretty easy to create new digital assets, new tokens, sell them, or even promise that you're going to create new digital assets, sell them, raise money, and go off and build something. And that's what we loosely call ICOs. And we all probably can remember the countdown clocks and every which other thing on websites. And the SEC weighed in and said, look, we looked at these, and most of these ICOs we think they're investment contract transactions. And Chair Clayton, who preceded Chair Gensler, was pretty clear about that. What wasn't really addressed at that time is, okay, well, those sales of the digital assets, they need to be registered with the SEC because you're fundraising, people are taking money, and they're promising to do things for other people. Hey, we got laws around that, just like Margaret said. But that didn't really come up at first. And then we had this problem around, well, what exactly is up with Ether? And, many users of Ether were concerned that somebody said, well, is the Ether token itself a security? And so we see this Bill Hinman speech, which became such a kind of cause celeb as part of the Ripple action. And Hinman, who was the director of the Division of Corporation Finance of the SEC at the time, came out with this quite important speech. I think, Margaret, it was the summer of 2018. I don't think it was 19.
I think it was 19. It was 19? After the gatekeeper speak by Clinton.
Yeah. So thank you, Margaret. And he comes out with a speech and he says, well, maybe when Ether was first sold, those were regulated transactions, but now people can sell and not be regulated. And he said, well, the difference is it's sufficiently decentralized. And much of the legal community kind of jumped on this. Okay, and although he never said Ether itself is or is not a security, people kind of took it that way, and then assumed that basically what he's trying to say is whether a token itself is or is not a security is a function of how decentralized it is. And therefore, you had all these people running around sort of focusing on decentralization, a critical point, but sort of whether tokens are or not securities, and you have these sort of tests and checklists and all kinds of different things. And it was in this environment that we said, I don't know if that's really how the law works. And some of the early cases really sort of left ambiguity in this, what the judges were actually trying to say about this. And so Judge Torres is the first one in the Ripple case to really clarify. She's, first and foremost, the XRP token is not itself a security. Let's just be super clear about that. The SEC...
Wait. Let's pause, Lewis, because we want to be really clear here. When he's talking about what the judge said in this case.
Yes,
don't go off and run and say this is a legal opinion and you can do this. Yeah, because I can hear some listeners will just cut off right now and say, great, I can go off and do this.
Oh my God, no. Yeah, Lord knows we're not going to be doing that. No. But so she says, thank you for Glitz. Awesome. So she says, first and foremost, in my view, the judge, the XRP token is not itself a security, but more importantly, she makes this other statement, which for me is really kind of the key statement in the whole opinion. She says that the XRP as a digital token is not in and of itself a contract transaction or scheme that embodies the Howey requirements. And this idea of embodiment is something we really kind of latched onto because that was really the SEC's best argument. Okay, fair enough. A token's a number. Okay, we get this, right? But, the reality is, the economic reality is that's how the scheme passes itself down from person to person. And as the embodiment of an investment contract transaction, everybody's doing a securities transaction.
Well, let's back this back. I'm going to say, let's make this digestible for non-lawyers a little bit here, which is the argument that started to arise with the SEC and the argument that the SEC made in their pleadings in the Ripple court. And you've heard Clayton say it. I've not seen a digital asset that's not a security. He is focusing on the underlying assets and saying those assets are securities under the Howey test. And that really is the primary argument they've been making. However, in looking at the Howey test, and I have to give great applause to Lewis on this and Paradigm, because if you read, there's something called an amicus brief, which is a friend of the court brief that they were allowed to file in the case. And if you read the Paradigm amicus brief, you read the SEC's briefings and the pleadings in the case, and you read Ripple's pleadings in the case, basically the Judge Torres said, I really like what Paradigm, aka Lewis Cohen, wrote over here, and it really was what is in this amicus brief is this concept of what is the Howey case about, and just going back to it, the Howey case focused on here is something that is not a traditional security that we're used to. This is not common stock being issued by a company, but we still might have to bring the protections of the securities laws to that because it's an investment scheme or contract or transaction. So Howie involved the bunch of people coming together, and Howie was a guy who said, I'm going to plant orange trees in a big grove in Florida, in Howie, Florida. Right? There's a town named after Howie, too. So you can go there still. So he said, hey, investors, help me support this platform, AKA an orange grove. Give me money to do that, right? And as a result of it, you can get money that I raise out of this, or you can get oranges. So I want you to think of those oranges now as digital asset tokens, right? And the Howie case, like, what's great about this decision and what Lewis has promoted here is we focus on the manner of sale, right? We focus on the investment transaction or scheme, and we don't confuse this with the underlying asset, oranges or digital assets. Securities, the crypto bar, the legal bar, has been making this argument with the SEC and talking to them about this since 2017. When the Hinman speech came out, when we took it as like, oh, they're getting it, right? They're getting this. Like, it's moving towards that. And then flash forward, we have a change in administrations. We now have Gensler come in, and all of a sudden, we're moving to this like complete hard line of, no, we're just looking at those oranges. We're looking at those tokens. So why we're all excited about this case is it went to the actual how we like we've been told again and again, there's an existing case you should look at, and we keep saying yes, but you're not looking at that case. You're not reading that case. Practitioners who've been securities laws practitioners for a long time would tell you you're misapplying this case by saying every digital asset, every orange is something. So that's why this case is so exciting from a securities nerd's perspective, and it's exciting because it is a win in the battle, right, for us. I'm sorry, Luke.
Rachel, we promised to nerd out, and hopefully we're delivering it.
Yeah, we're nerding out, but we're also trying to make this digestible for securities law geeks.
Of course. No, this is good. Especially I like, the comparison of the oranges because that makes a lot of sense. But Lewis, I want to go back to this amicus brief. I hope I'm pronouncing that correctly.
Yep.
That you wrote or helped write. So in that brief, did you actually say, or did you write that the Howey test should be considered, and then the judge took that into consideration and was like, oh, it just makes sense now?
Well, we obviously don't know what, the judge did in her chambers. And also, I want to give a huge, as somebody who's also a good friend, Margaret, I know of you, we did that together. You alluded to another law firm. It's Jenner and Block, and the lead partner there, Kayvon Sadeghi. And Kayvon is just an awesome lawyer, a great guy,
Incredible.
a key. And look, I'm not a litigator, and neither Margaret and I are transactional people. We're not writing, 20-page, awesome, fantastic briefs. So Kayvon was a huge part and collaborator and teammate and colleague. So I just want to give giant shout out to him and his firm, who are awesome. In terms of what we said, I think you can read both the brief itself, which is reasonably succinct, it's 25 odd pages, I think, as well as the big article, which is a good bit longer. And I think you quite clearly come away with the fact that our core argument here is around this idea of what we call the SEC's embodiment theory. And to my knowledge, Margaret, before we started talking about that was just not part of the dialogue. The dialogue was really have you been sufficiently decentralized such that you're no longer a security? And so we really sought to reframe the argument, not are you. Now, again, I want to emphasize over and over again, decentralization is critically important from an economics point of view, from a legal point of view, from many different points of view. Just it's not how you determine whether a particular asset is or is not a security, right? So when I say I'm not discarding. I don't want to say Lewis doesn't think decentralization is important. It's critically important. It's just our argument is we look at a digital asset. If we don't see something that represents rights or an interest in a company, then we have to evaluate the specific transaction that it's in. So the judge's adoption of the term embodiment in that sentence I read, also her focus on a Ninth Circuit case, which others have raised, but we wrote about significantly, which is, Margaret, you may recall, which is the case of Hakim versus Dubois, which really is probably, we looked at 100% of all of the kind of important cases, the appellate cases, we call them in law. and analyze them and attach them in the end of the article. And the one case that really was highly relevant here in terms of secondary transactions was this Hawking case, which involved a condo that was being resold. And there, the Ninth Circuit, a very important court, said that, look, in a secondary sale of something sold originally an investment contract, it's not automatically a securities transaction. You got to look at those circumstances. And Judge Torres really just takes the Ninth Circuit at its word, takes, I think the law at its word, and says, I'm looking at these specific transactions. I don't see in these programmatic sales, and Margaret, maybe you can talk a little bit more about those. The history relevant being at an exchange now. And she says, in those transactions, I'm just not seeing the 4 elements of the Howey test. Simple as that.
Yes, and this is really interesting. When we see kind of the reaction people are getting to this, which is like you have these institutional investors, category 1, who the judge found that the manner of sale, how these things were sold, was a securities transaction under the Howey test, right? And those are sophisticated people. But then we get to these what are called programmatic sales. So this is when Ripple was selling in blind bid-ask sales, and they sold a lot. I forget how much it was, but it was
like 700 million.
700 million. So it was a lot sold that way. On platforms, sometimes on exchanges, but I always just say platforms depending on how they were done. But the buyer was buying Ripple, the asset. They did not know that they were buying it from Ripple. They didn't know who
XRP the asset. XRP the asset.
Sorry. XRP the asset. Sorry.
Yeah.
XRP, you are correct. XRP the asset, the token, and they didn't know that the seller of it was Ripple. So it's a blind big ask, and that's something that's a programmatic sale on an exchange. And the judge's decision there said, well, let's focus on this manner of sale and the Howey test. So. Is there an investment money? Okay, well, yes, there's an investment of money. Money's being exchanged. No, wait, what are they investing in? They're not investing in Ripple, a company, right? They're buying XRP. Okay, common enterprise. So are they all getting together to try to, with Ripple to try to referral? Third part is really the reasonable expectation of profits from the managerial efforts of others. So if you don't know that it's Ripple selling it, how can you have a reasonable expectation of profits from their managerial efforts? And she said, this is where she kind of concluded this. Now, this is going to be something that is going to has already been picked apart, right? Because, Ripple and other studios and labs that are creating these tokens and they get decentralized into foundation, they're doing tremendous marketing efforts. They want that to go up. So I think there's still going to be, like, is this case the end all be all? No, there's going to be really picking at this part of it, and programmatic sales, and whether, how much marketing can be done. The other thing I would say is putting aside everything going on in the U.S., remember that there's lots of jurisdictions out there that are focused on the marketing efforts going on of all these groups. Look at what's going on in the UK and the new marketing guidelines in Dubai. So not securities law, just plain out, like, no misrepresentation, no fraud, no collusion. Your marketing efforts have to be above board. So projects should always remember that. But the programmatic part is interesting. And then the third category that she looked at, which is the compensation of employees. Now, this is, I think we're going to have a lot of commentary on this one. But, if I'm an employee of a regular company, I get stock options. I get restricted stock. Well, that's equity in the company. It's clear that, like, if the company liquidates, I have a claim on some assets as the result of that. Like, I actually have a claim in interest of the company. Here, her saying this method of sale, this manner of sale, does not rise to an investment contract is very interesting. And she's differentiating that from the traditional stock options. But there's something called Rule 701, which is an exemption when you do that. All of those things focus on equity. So remember, the Howey test arrives to define what an investment contract is, right? We already it's clear under the securities law definitions of what equity is. And so she's pushing away the digital assets because it's not seeing them as equity. Therefore, we have to evaluate them under Howey. And this is a really very interesting result for that. So now, what does this mean? Can we rely on this? On Lewis, are you going to give legal opinions based on a district court position that's appealable, right?
Yeah, no. I mean, well, let's like Rachel. I'll get a question in, but yeah,
Yes,
no,
go ahead.
nobody's giving opinions anytime soon. Agreed.
Yeah.
Agreed.
Yes.
So there's a lot to unpack here, Margaret and Lewis. Even I'm a little bit confused now. But okay, so what we've determined is that the XRP token sold on digital asset exchanges is not a security, but the XRP token that was given to employees, correct me if I'm wrong, is considered a security still. No?
Not a security.
Not a security. So,
Yeah.
but this was a
It was 50-50 there, so
this was a partial win for Ripple. So what is considered a security? Nothing now?
No, as Margaret was saying, the institutional sales, and I just want to clarify, Rachel,
sales, okay.
because this is super important. It's not, as Margaret was explaining, it's not so much that the token, when sold to institutions, the token is a security. It's the transaction in which the token is sold. So it's not that the token is changing. I think that's caused a lot of people confusion. Well, how can it's a security when you sell to Bob, and it's not a security when you sell it to Jane, and how does that work? No. It's just, as Margaret was just explaining, it depends on what's the character of that particular transaction.
Okay, so institutional sales, that's a security.
Well, and even there,
The
let me
sale.
back
The
that up
sale.
and break it down. Yeah. It's not so much that there's institutions. What's relevant to the judge is that someone walked in the door, as it were, went into a conference room, as it were, sat down with Ripple people, discussed giving Ripple people money, discussed getting in exchange for that money tokens, and then considered what Ripple was going to do to make sure those tokens would be worth more in the future. It was those arrangements, right? It could have been an individual, could have been one wealthy person coming in the door, as it were. Right? It wasn't so much that it was an institutional sale, it was a direct relationship between the buyer and Ripple Labs. What distinguishes the programmatic sales is there's no relationship, as Margaret was explaining, between Ripple Labs and any particular buyer. They don't know who they're dealing with, as Margaret was saying, blind bid ask. That's hard to say. Blind bid ask. They don't know who they're dealing with or why, and they don't care. And a lot of people, Rachel, have said, well, of course they're buying it because of Ripple, and for sure, some people were buying it because they thought, man, those Ripple guys, they know what they're doing. But many people were buying it just because it was there. I've heard lots of stories from lots of people. I want to buy the top 5 cryptos. What are they? Bitcoin, Ether, Litecoin, whatever, and I'm just going to buy those 5. Why? Just because, there's no inherent connection because that person didn't walk in the door, as it were, and say to Ripple, hey, I got some money. You got any good ideas what I can do with it? And Ripple says, sure, I got a great idea. Give it to me, and I'll give you some of these tokens, right? It's this relationship that...
Lewis, I don't know. Like, I think focusing on the relationship could be a little... Like now let's look at it from category 3, where the judge found they are not... the manner of sale of granting compensation to employees is not... a securities transaction. So those employees are sitting there directly and have a relationship.
Right. That's
100%.
confusing. It's confusing.
So, well, how is it? How
she
go through it.
That's a great point because that is the weakest part. I suspect Margaret will agree with me. It's the weakest part, Rachel, because she focuses on a different prong. So you have to have all 4 prongs. You lose one, you're out. And so in the case of those sales, Margaret, exactly as you say, she focuses not on this expectation of profit thing or the relationship thing, but on did you invest money? And she said, well, these guys didn't actually give capital to the business. They just were working there, or they were just providing some service. And so there was never an investment of money. But that's, I think that's not the best argument. So
I know. I've been working the third category. Lewis and I have to go and sit down and have drinks over it and figure it out. That part. It was the shortest amount of space in her entire opinion that she devoted the language to. So what's the takeaway from this? Like Ripple, like people are saying, okay, so Ripple did something illegal because they sold to these institutionals. That doesn't make sense. No, it was the fact was that it should have been treated as a security transaction, and that manner of sale should have complied with securities law. And what Liberal didn't do is they didn't do a Reg D. Like they didn't get the right reps. They didn't warn the people about the things they do. They didn't get the promises that you have to. They didn't file a Form D. They didn't. And you don't just, a lot of people are saying you must do a Reg D. There's other exemptions. I want to be clear on that. So 4A2 doesn't require you to do a Reg D filing. So there's other ways to do that. So don't have a securities lawyer tell you you're unsafe unless you did a Form D. But they didn't bother to do anything. Like what they did is they met with people and they said they did all, like, you know, they had their deck, I imagine, and said, here's what we're doing. And they may have been accredited investors, but they didn't get them to bother to represent or do all the things they needed to do for that. And this could have been an outcome. This case, if they had a good securities lawyer at the beginning, what I hate about this case is we could have won all three, because they could have done a proper exempt offering under number one. Number two would have just been, you don't need an exemption because it's not the method of sale, the manner of sale is not an investment transaction. And then number three, the same thing. So we could have had like a home run. Instead, now we have the SEC going around saying, we won on number one. And, well, no, you actually really didn't.
Kind of more of a ground rule double, maybe. Ground rule double.
Yeah. Well, no, because they didn't win the argument they were making, which is that digital assets are securities.
Right.
And that's the key to
All
this
right, Rachel, I feel like a question bubbling up in there.
Go ahead, Rachel.
Yes, the question is this. Margaret, when you were saying they didn't file a Reg D, they didn't do this, they didn't do that. I think this is the problem, is that there's not a clear regulatory framework for digital assets in the United States. So how could Ripple have known what to do? So do you think that was the case? They just didn't know what to do? Or do you think that they actually they were just like lazy about it and just did whatever they wanted to do?
I mean, I don't know. I mean, this was back, 2010, Lewis, right?
It's a little later than that, but it's a little later, but still, it was early on in the process.
I wasn't in there, and first of all, like, hey, regardless, let's give a shout out I'm all Team Ripple right now. Thank you, Ripple, for fighting this, putting the money into this, and this is what we need people doing. We don't want them to go settling things. Like there's some companies that settle, and Lewis and I are like, you shouldn't, like, that's such bad law. You know, stuff on the Reeves test relating to staking, other things. It's such bad law that you're precedent, and you're settling with the SEC, and we wish you would fight. So thank you, Ripple, for fighting this. I don't know. I can't go back and know what they did. Sometimes when you're starting out as a startup, you can't afford to hire an attorney, right? Outside of the crypto space, how many times have I had startups come to me, and it's like 2 years down the road, and it turns out I have to go clean up how they sold common stock, right? To people, because they didn't use proper exemptions. We might have to rescind, etc. So I'm not going to bash anybody who's had to clean up. That happens all the time. Outside of crypto.
I would completely agree 100%, 110% with that, Margaret. I would say, Rachel, look, when some of those early sales were done, people weren't quite as clear as how things work. I think if we focus on where we sit today, I think it's clear enough that if you're inducing people to give you value in exchange for tokens, and there's some U.S. jurisdiction in the mix here, somebody's a buyer, seller, somebody's in the U.S., then you need to comply with the securities laws. I think that's well settled, and has been well settled for now. Got
it. Okay. I also wanted to say this. I'm on Twitter a lot, and I see everyone, and even I posted on Twitter, it's a huge win. Thank you, Ripple. This is amazing. Major milestone. But what I want to make clear is that we still, in the United States, we still don't have a clear regulatory framework for digital assets because of this court ruling. I think a lot of people think, oh, now there's a clear regulatory framework in the United States, and let's go in and build a company and sell tokens and this and that. But there isn't. Am I correct?
I'll pick up on that one first. Yeah, you're absolutely correct. I think, and it ties in, Rachel, to a point that you see in a lot of the criticism around Judge Torres's ruling, is that she got it exactly backwards. If you look at the critical pieces on CoinDesk and elsewhere, they said, well, wait a second, the securities laws are meant to protect the institutions, and then here they're protected, and the retail's not. She got everything backwards. She did not get anything backwards, as Margaret and I have endeavored to explain. However, she did expose just a gap in the regulatory framework, which is exactly your point, Rachel. There is a gap, and I think if there's a mistake here, and I'd like to think it was well intended, but whatever, the SEC went to Congress, and the chair told Congress that they had a complete regulatory framework for crypto, and they didn't need anything else. They do need something else. And if you can somehow survive to the end of our paper, the last, give or take, 5 or 6 pages, we talk about policy, and we point out that there absolutely is a gap. It's a completely fair concern, and that needs to be addressed by Congress, though. We can't have judges trying to fill in holes that Congress has not done. And that's sometimes characterized as the major questions doctrine, although that gets into its own complicated set of issues. Yeah. But at the end of the day, there is a gap, and how do we protect the buyers in these markets? And we have really major policy proposals out of both the House of Representatives and the Senate, through Lummis Gillibrand in the Senate and McHenry, G.T. Thompson, was just reintroduced last night, as I'm sure, Margaret, you saw. And look, yes, whether those work in their current form, whether they should be combined, whether we should start again completely, that's a long discussion. But Congress is aware that we do need to act. So sorry, that's the story.
I think it might be helpful because I know Rachel has a lot of global listeners.
Yep.
To explain just briefly my favorite thing, which is how the different branches of our government work and what they're supposed to do. So Congress makes a law, and I always call it this, the people in the U.S. will know this, Schoolhouse Rock. You can go, there's a famous little Schoolhouse Rock thing about how a bill becomes a law. They make the laws. The executive branch, and the SEC sits in the executive branch, the White House sits in the executive branch, IRS, CFTC. Their job is to implement those laws within the power they've been given within the laws. The laws usually allow them to issue regulations and have some broad authority. And the SEC over the years has gotten very broad authority, and they needed that broad authority because they are dealing with our stability of our financial markets. It's important. We want them to have that kind of broad authority. However, when there's dispute about how they're implementing those laws, then we go to court, right? And we have these disputes, and that's where the judge is. And the judge's job is to interpret the law. So Judge Torres here she's dealing with the law as it is before her. She can't make new law. She can't say, it is kind of a strange outcome that we're saying it's illegal, how this manner of sale to institutionals is legal, but this programmatic sales to retail investors who might be moms and pops is perfectly okay, that manner of sales, and then employees, perfectly okay. It seems like almost like the reverse is logical, but she can't make law. And this is why Congress, which makes law, has to do this. So people who from different countries who don't understand how our government works, every government around the world is different. So that's sort of what we've been grappling with in the U.S. And having the chair of the SEC go testify in front of Congress and say, the law is perfectly fine. We know how to apply it. Well, what this case says is no, the judges are saying no. And if you look at what's happening in the Coinbase case and already the first hearing happening, we're getting signals that judge there also is feeling a little like, we don't know that you're actually implementing these laws correctly.
Got it. That was, Margaret, that was a great explanation. I mean, even I understood it. And it's hard for me to understand these things because I'm not a lawyer, although I do wish I went to law school because this is really interesting. It's interesting
I want someone to find me a Schoolhouse Rock bill t-shirt. If anybody out there has that or hat, I've been looking for one. Oh boy, I would love to just do that. And I constantly will link that little branches of government speech.
Yeah. So the SEC basically, the SEC was like, there are clear laws. And then this case said, well, actually, there are not clear laws. SEC, you're wrong, which is why Gary Gensler is all mad. Right?
Yeah, they're saying, here's how we apply the laws that exist. And Gary Gensler, you're not going to like it.
Right. Got it. Okay.
Because we have the judicial branch has to interpret the laws that exist.
Got it.
And the result is, I think there's Rachel, isn't there a representative that you interviewed?
Yes, yeah. Let's talk about that just real quick, Margaret. Representative Richie Torres, who coincidentally has the same last name as the judge in the XRP court ruling. I interviewed him on the phone a few days ago for Cointelegraph, and he said something very interesting, which didn't cross my mind initially. So I want to get both of y'all's thoughts on that. He said institutional investors are the ones that are protected here, but retail investors are still exposed. Do you guys want to comment on that?
Lewis, you take that one.
You want me to go first? Yeah, so it depends what you mean, by exposed here. They are buying an asset, but they are not, that is actively traded. But if it were registered, the person that would otherwise have been the issuer would have had to provide disclosures. It's important to remember, like the SEC talks a lot about, we'll just come in and register. What is the consequence? Like what in the world would be different, right? And one of the main things that would be different is that Ripple, for example, would be providing information to the market. They are not providing, regular information to the market. They provide some information, but not the way you would. And so, a new bill would provide, there's the bill. I want that bill t-shirt too. So we provide that information. So yes, Representative Torres is right in that it's not just those purchasers, but a market that's active needs accurate, up-to-date information. And so the issue is we don't need that for Bitcoin, because everybody's reasonably comfortable that there's no single point of failure for Bitcoin of information like, hey, you've got information that nobody else has. It's much more like a traditional commodity. Other commodities and other digital assets may have single points of people who have better information than others. And a principle of our markets is that they just work better if everybody has access to the same accurate information. And so the failing here really is, how do we get projects where there is still a labs type company, somebody like XRP, who has information that could be relevant? For example, there's a new version of the platform coming out. We're up to V3, and now there's going to be a V4, for example. So some people will be aware, oh my God, that V4 thing is incredible. It's really important. Do they have trading bans on those people? Who knows? How do they tell people that? Some companies are well run and manage that. Others are not so much. So what we need to have is, as with public companies, disclosure, but we don't need to impose what I call securityness onto the asset. We just need a new framework so that everybody has access to accurate information.
Okay, so I'm gonna go out with Lewis knows that I love to think about other world examples and try to apply this here. So I'm gonna talk about StockX. I'm gonna talk about sneakers, and I'm gonna talk about my almost 21-year-old son. So my almost 21-year-old son, when there's
Teen bride.
There's some new like big sneaker that drops, he goes out and he buys up 10, 15 of them, right? And he go and because there will become scarcity soon because they don't produce that many of them. Okay, but flashback to the institutional investors, the accredited investors who funded that sneaker company at the beginning, in order for them to be able to produce those sneakers and to have their manufacturing plant, their platform to make those sneakers. That manner of sale to them to buy, and maybe they didn't get equity. Maybe they got some equity, or maybe they got just a promise for a bunch of future sneakers. Like, all right, so instead, hey, I really, really believe in this new line that you're producing, Nike, but in order to produce it, you need to have some outside investment, maybe $10 million, because you got to get a contract with this person or that person. You have to have a whole new manufacturing line built for it. And so give us $10 million. And when we launch these sneakers, instead of getting equity in us, we're just going to give you a pro rata share of the sneakers that we're launching, right? And so they launched their new whatever, Air Jordans. I'm not a good person with brands, so I know I'm going to get trashed on this, that I messed up the brand. So let's say some new like big popular athlete, new brand of sneakers comes out that has been funded by these institutionals, right? And all those institutionals get a bunch of those, and also my son goes to the store and is buying those, right? But then my son is going on a StockX and he's putting those up for sale, and you don't know who you're buying it from. It's programmatic sales, blind bid ask. It's auctions going on, and he sells them to the largest people, right? But maybe also Air Jordan held back a bunch, and they're doing it too because they're trying to pump up the price of their sneakers. So they're selling them in stores, but they're also selling them at StockX. And by the way, lots of brands do that. right? They do hold back a portion. Not everything is being sold in their retail stores, right? And they're promoting those. They have commercials, they have all these marketing, they have all this stuff going on. Are those sneakers securities? The method, but is the first sale, the method of sale that happened for those initial people who whatever sneaker company came to them and said, hey, help us because we need some money to fund this new sneaker line we're doing. They got sneakers. That method of sale to them definitely was an investment contract, right? The sneakers that they got were not securities. The sneakers that my son bought and then resold and made money on are not securities. And the same company.
That's a great, I mean, for me, for whatever it's worth, Rachel, I think that's a fantastic example.
And then they gave, every employee got 10 pairs of sneakers. And then I went and sold my 10 pairs on StockX and made money that way. They're not securities.
Right. Lewis, what were you going to say?
Because how?
No, only going to, I'm not worthy. So do my little, I'm not worthy there because it's a great example. We wrote an earlier, shorter article on Broadway tickets because Chair Clayton had used the analogy of Broadway tickets and said something similar. But I think in just a few sentences there, Margaret, you really hit the nail on the head. That you can build up these examples that make it clear that their objects are different from schemes. I mean, that's really in the most simple and basic form. And that when two people who are not part of the scheme trade the object, they're not in a securities transaction with each other. The person who's the schemer, yes, they need to be regulated, but the people just exchanging assets, and that, for example, for an exchange or a broker-dealer or others, they need to be able to assess whether when they trade an asset, be it sneakers or tokens, are you entering into a securities transaction? Because they're wildly different regulatory outcomes, wildly different. So I think the point Margaret's making here for your audience is that what Judge Torres did, which is so important, is she recognized this difference between the scheme and the object, or that comes out of that. Interestingly, there's a very simple bill also in Congress that hasn't gotten as much attention recently, but has been reintroduced by Tom Emmer, who's now the House Whip, and it's called the Securities Clarity Act, and it goes really just to that very point. Just nothing else, no frills, no nothing, just recognize the scheme object. But in many ways, Judge Torres has done that for us, at least in the Southern District, and at least until there's an appeal. I know we're going to be running out of time in a little bit. I don't know, Rachel, if you'd like to talk about sort of the what's next part, because I know that's really interesting, of like appeals and different things. Maybe that's something, Margaret, if you want to pick up on or stuff.
Actually, I do want to talk about the what's next part in the little time we have left, because Lewis, when I interviewed you for the article I'm writing, you mentioned that an appeal by Congress could happen on the court ruling. That Congress...
An appeal by the SEC? An appeal by Congress? No, not an appeal by Congress.
Okay,
You know what I mean?
What did you say?
Well, not an appeal. Congress doesn't appeal anything.
The SEC?
SEC.
Okay, sorry.
Yes,
That's
the
what I
SEC.
meant
Yes,
to say.
appeal by the SEC. No worries at all. All good. Just want to make sure. So I'm paying attention in class. That's all. I got Professor Rosenfeld kind of keeping an eye on me there. I'm trying to sit in the back and so maybe she doesn't catch me smoking.
Wait, one thing I have to. I know we have a little time left, but who talks faster, Lewis or me? That's going to be a poll
Margaret,
at the end of this.
You do.
Damn. Okay, I always lose. Go ahead, Lewis.
I'm not worried. So let's talk quickly about appeal, right? So first and foremost, the number one thing is this is not a final judgment, right? So she decided some of the issues that were before her on this summary judgment motion, which is basically summary judgment is when both sides agree to a set of facts. They say there's no facts in dispute here, it's just how you apply the law to the facts. And so she decided, as Margaret explained, in favor of the SEC on the institutional sales, in favor of Ripple on the programmatic sales, and the other distributions, as we're calling them, and also in favor of the individual defendants on their sales, which were more or less programmatic sales. However, so she resolved almost everything, but she didn't resolve everything. What she did not resolve was the status of the individual defendants vis-a-vis the institutional sales. So if the individuals had what we call aided and abetted, helped out, if they had responsibility for the company violating the law, they would have personal responsibility at that point. And she said that we need to have a trial on that. So because she retained those issues for a trial, her order is not final. Because her order is not final, because there's still pending issues, the SEC cannot appeal this decision as a matter of right. Normally, when you're done, dusted, it's up to you. You want to appeal, you don't, up to you. This is called interlocutory. So something that's in between. We're not done yet with the process. And in an interlocutory situation, you need the approval of the judge in question, and I believe also of the appellate court. So it's no easy thing. So the SEC could theoretically appeal now. However, they need the judge's permission and the appellate court's permission to do that interlocutory or in-between appeal. Unclear. I believe they have 10 days to make that decision, which would put us at Monday. So we'll find out soon enough. I don't know when this is going live, so we may already know. So we'll know whether they do that. They have other pathways. For example, the SEC could settle the charges with the two individual defendants. If they settle the charges, then there's nothing pending. And at that point, in theory at least, if they wanted to, the SEC could appeal as a matter of right and move this up to the Second Circuit.
I give it like a 0% chance of settlement because I don't think Ripple or Coinbase will do that. They have.
I'm just saying as to the individual defendants, just as the
the individual. Oh, the aiding and abetting. Yeah, the aiding and abetting.
So that's a small potatoes thing because the worst outcome for the individual defendants is a fine that they can probably afford. So I'm sure there's some number that makes everybody kind of willing to make that just as to the individual defendants. So my point here, Rachel, is a kind of a complex 3D chess game as to who does what. And the super short of it is nobody's got any good idea because the parties are evaluating their options. There are benefits and risks to appealing as well for the SEC because they might win and reverse Judge Torres, but they might lose and then make permanent law in the most important district probably in the country, in the circuit, in the country. So that's a risky thing. An alternative thing is to let it be and fester for a while in a slightly uncertain state, which could go on. For example, if the trial goes forward, they may not have the trial until next summer. These things just take forever. So it's just, at that point, it would be just a festering order that's not really fully final. And they could pursue other things. They're pursuing Binance in the District of Columbia, the DC district, and Bittrex in the Western District of Washington State. Those are two separate
and Coinbase case is in the same district with a different judge.
Yep.
So the same circuit. So it's very interesting.
Wait, Coinbase is in New York, Margaret?
Is in the Southern District of New York, with Judge. How do you say her name is?
Fela. I believe it's Fela.
Fela. Okay. And so you asked next steps or what's coming next. Like a short dramatic reading from the transcript of the Coinbase hearing that happened right after this. And this is so Coinbase is being sued by the SEC, similar facts, but an exchange, and we have a much more engaged and aggressive judge at the beginning of the case than we did with Judge Torres. Judge Torres sat back, took all of it in, and then put out this result that was, just truly not what I was expecting from how much she did not comment on things in court. It was hard to read where it was going to come out. But now, let's just a dramatic reading of here's a court's question to the SEC. This is the court. Is there some significance that I should give, or maybe there is none, to the fact that the commission, that means the SEC, issued the S1. The S1 is the registration statement that Coinbase filed with the SEC when it did its IPO. So to the fact that the commission issued the S1 and didn't say, hey, watch out, guys, you're engaging in securities laws violations. So she asked that question in that way. These are the exact words. And the answer from the SEC's legal counsel, the short answer is no. Your Honor should take nothing from that. And then the court says, let me have a slightly longer answer. So she's saying to them, come on, guys. And then he says, Your Honor, I'll simply state that because the SEC allows a company to go public does not mean the SEC is blessing the underlying business. He says more, but I'm just being short here. The S1 is about disclosures. Okay, and this is my favorite line. The court says, let's just pause. Let's just pause. So when a judge says, let's just pause, that's not a good sign. So I can just sort of get rid of the skepticism I currently have as I hear that answer. I love this judge so far, right?
Yeah, that's
And
an
then-
ouchie. That's a real ouchie.
That's an ouchie. So, and then she goes on later to say, but it's not crazy in the Fela parlance. So she's referring to herself for Coinbase to think that what they were doing was okay because it was exactly what you let them do when they issued the S1. I cannot wait to hear more of this judge and more of this case. But if I were the SEC, the judge is like giving you some strong signals right away. And this is why we need Congress to act. So what's next? We are going to, do we need another 3 years of having now our judicial branch and our executive branch going at each other this way? We need Congress to start looking at these frameworks and help us with this and direct the SEC how they should be applying the framework to digital assets.
Thank you, Margaret.
I pause on my dramatic reading.
That was, you should be a teacher, seriously. I mean, this is really good stuff. I mean, both of you, I'm learning a lot, and I'm going to go back and listen to
Lewis,
this podcast.
you and I should go teach a class together somewhere. That would be so much fun.
I'd love it.
Yeah, and I can be in there taking notes.
We teach a class in the Bahamas. That's what I want to find out.
So I don't know. Maybe Australia.
They have better beverages. They have better beverages there, I'll tell you that.
Oh, Sydney's so much more fun. I'm really excited to be launching there. A Cube Exchange there.
Well, and maybe give Margaret, maybe because we probably need to wrap up, but give Margaret an opportunity just to touch on to the extent you can, what's going on with Cube. And,
Margaret, are you guys going to launch in the United States?
So I'm very excited about the results of the case, but we still are not offering our product services within the United States. We chose Australia as our launch country, and we started our wait list from there. I went to Australian Blockchain Week. I had interaction with government regulators, practitioners there, all kinds of different folks, banks, and it's such an interesting different way that they interact with the government. It's more of a consensus approach that's occurring. More learning about what's going on in the industry, and the players there in the crypto industry are concerned about the right things: consumer fraud, anti-money laundering, all the things we should be concerned about. So what Cube is doing is a centralized and decentralized approach. We're taking the best of both worlds. Our decentralized approach is an MPC wallet that completely separates the assets from the exchange, never touches it, non-custodial, they're always yours. That means no omnibus, nothing omnibus. However, all of it is also runs through KYC AML. We have consumer fraud checks. We're not having elderly fraud, all the good things. And we see it as the next generation. Regular securities exchanges, you do not take your Apple stock and say, here exchange, put it in an omnibus account and hold on to that. And I trust that you're going to do everything proper with that, right? So we've built something that does that and allows direct links to it, but the exchange, we can't touch it. We go bankrupt, it's still yours. We can't go and give it to some hedge fund over here that we like. We can't use it to cover other things because we never touch your assets. We just manage the trades.
Got it. And you will not be launching in the U.S. anytime soon because there's still not a clear regulatory framework for digital assets.
But what we're doing in designing this is designing it completely with the compliance and everything that is designed to provide stable financial markets for digital assets, protection for consumers, not having to trade with a terrorist, all the things that we want in these exchanges. We're designing it that way. So when the U.S. is ready, I can't wait to bring it to the U.S.
Well, it's good to know that you're on board as the chief legal officer. That's awesome. Every crypto exchange / company should have a CLO because it's
yes. And Lewis, you have to apply for our Twitter account so I can get you a Cube number. Awesome. Rachel got her Cube number.
Can I ask a quick question? So how are you sourcing liquidity, or have you said yet?
We'll be announcing stuff about that.
Okay.
So I can't tell you all here, but we'll be announcing
perfectly fair because that's that's the enchilada right there. Yeah.
We can do a recap, a follow-up interview.
Part two.
Okay, for our listeners, because I'm sure they're really excited.
Yeah, Rachel, thank you so much. Again, having somebody who really understands how Web3 technology works and the entire industry be out there and being able to bring this type of content is just wonderful.
Yeah, well, thank you both for joining me. Before we sign off, how can our listeners get in touch with you? Lewis, should they get on Twitter, tweet you,
Yeah, they can certainly, tweet at me. It's NY Crypto Lawyer. They can message me. My email's on our website, which is www.dlxlaw.com. So happy to hear from folks.
Cool. And Margaret?
The best way to find me is find me at Twitter, and you can DM me or you can tweet at me. It's at M Rosenfeld. But my handle, my name is Agent M. So everyone just calls me Agent M.
Nice. And I'm going to say, with to wrap up where I think we discussed before we went on live, Rachel, but the graphics and the design is all fantastic. And I think in a Web3 world, that stuff is important. And I think it really
part of community, like we're building a new way of trusting in DeFi and financial, but part of the community for the generations with the wealth who are putting this into Web3 and the financial trust of Web3, they also trust by fun. Like they want their community to be fun. So you got to have some fun in this.
Right. Well, Web3 is fun, and I hope I'm making it fun for everyone. And you guys are making it fun, even though it's all, we talked about crypto law, which might not be the most fun topic, but it is fun.
Lawyers are fun.
Lawyers are so fun. My dad's a lawyer, so hey, yes. Grew up having fun. Okay, thank you guys so much for joining us. And yeah, I'll see you guys next time. Thanks.